Hey there, everyone. It's Thursday. Time to make America think again. Welcome back to Law and Legitimacy, where, in an hour or so, I will begin day, what is it, Mike, 64 of the
Maybe
proceedings.
65, 64, 65. I've got 65.
Yeah, 65 in the Hotel California, a.k.a. Gilligan's Island, also known as Joseph Biggs, also known as the Proud Boys trial. We're close to wrapping it up. We will not quite complete evidence today, but we'll likely complete it early next week. We're on the cusp of a 4-day weekend. For whatever reasons, this court closes both on Good Friday and the Monday after Easter by tradition. So it'll be a nice break opportunity for me to pack up and get ready. I hope to head home and to put my notes together for closing arguments. We don't know yet. In a criminal case, obviously, a defendant has a right to testify. Customarily, the right to exercising that right is the last thing that occurs in the defense case. So we've had several weeks of defense evidence. There'll be some wrangling about the scope of whatever evidence we can put on today. And then next week we'll come in and the defendants will have to testify. My hunch is that one will, one is maybe, and three won't. But you'll have to find out which ones those are by reading the newspapers, or maybe I'll tell you the day after it occurs. I've got a pretty good idea who's doing what and when, but I'm not sure about one of them. We've had sealed proceedings in the last 2 days that have consumed most of the 2 days. Yesterday, a reporter came in from the press to object to the sealed proceedings. We joined, the big Team Biggs joined in that opposition to sealing the courtroom, and we did so for interesting reasons. The press representative came in and said, there's a First Amendment right of the public to see a trial and to witness it. That's why we have public trials. And the court pointed out, well, there's a long history of sealing if it affects fundamental or compelling government interests, and then there's a common law right to do so in certain cases, and that's why I'm doing it. I can't tell you why, because that would defeat the purpose of sealing. And he thought the hearings were done, and when I said, well, Mr. Biggs joins in the opposition. We've had prior rulings from this court to seal the courtroom, and we haven't objected. But the issues that have arisen here are different from those issues. And Mr. Biggs has a Sixth Amendment right to a speedy and public trial, and he's not waiving the right to a public trial on these particular issues. And the judge wasn't too happy. I think the judge kind of went home last night, kicked the cat, and said, "Take that, Mr. Pattis," because there was a little bit of friction between the judge and I in the air yesterday. Summarized, I think at the end of the day, there's a lot going on, and I turned to talk to a counsel of mine. Wait, what's going on here? I'm trying to have a conversation with the government, and my view was we can talk to the government all fucking day. I want to talk to one of my co-counsel, but I just turned around and sat down and let him vent. It's his courtroom. I get that. But anyhow, so Biggs objected on the grounds that there's a right to a speedy and a public trial, and that the Sixth Amendment right is a personal right. And this is similar to the conversation we had about Trump and a potential gag order this week. I said to the judge, whatever right you have to manage these proceedings, that springs from your inherent supervisory authority. And whatever right the government has to a fair trial, that springs from your inherent supervisory authority. But Mr. Biggs has a right to a public trial, and that comes from the Bill of Rights, and that is a limitation on the power that any of these separate branches of government can exercise, including a limitation on your inherent supervisory authority. And he didn't like that. And so he closed the courtroom. And as lawyers like to say, that's an issue that's preserved for a later day. How do I like our chances? Justin Carter asks. To comment on that would be to run afoul of the rules of professional conduct. As I've said any number of times apropos the Biggs case, a lawyer's role is to not make statements out of court that could reasonably affect the proceedings. I don't think that any jurors watching this, they shouldn't be. If they are, they're breaking the rules. And if they are, and I tell everybody what I really think is going on, that would compound the problem. So in an abundance of caution, Justin, I intend to give a closing argument that I believe in. I intend to ask the jury to acquit because I think that's what the law requires. And it is my hope and expectation that the jury will follow the law. Having said that, I live in the Heartbreak Hotel when I'm not in the Hotel California. And as every criminal defense lawyer knows, heartbreak is an occupational hazard. So off we will go to, USA versus Biggs et al. And hopefully the case gets to I think closing arguments will take place as early as Wednesday of next week, possibly Thursday. There'll be 2 days we expect of closing arguments. Then the jury will get the case. Courtroom cynics say the jury's exhausted and angry at everyone and that they'll return a quick verdict just to get the hell out of there. I mean, the evidence in this case began January 13th. Pretrial proceedings, motions and whatnot started December 19th. We took a week off for the Christmas holiday and began jury selection January 2nd. So the lawyers have been involved for all but a week since mid-January. Jurors have been in the room on an almost daily basis since January 13th. There is a real sense of exhaustion and a desire to get this done. And all the lawyers, I think, are on edge too.
Norm, we talked a little while ago. I remember once upon a time where we were projecting the trial to take a couple of weeks in January. And we talked about with various viewers what the longest trial you've ever tried was. And this obviously takes the cake. Yeah.
Yeah, this is and I doubt I'll have one that's longer. I mean, one of the guys in the case, his father is a lawyer, and he said his dad is taking an appeal off of a 7-month trial, and we just kind of looked at one another, and he said, "Wow, I mean, I can't imagine having a practice to return to." I mean, I have that issue as well. My firm, Pattison Smith, is still open in Connecticut. My partner Kevin Smith is doing, I suppose, what he can to keep the ball rolling there, but I'm told my absence is felt, and I can't say I'm anxious and eager to get back, but it's been a long haul, and so let's see what happens. Send your chaos our way. We'll make the most of it that we can.
Lawyer Will says the just annoyed Norm made him work harder.
What's that?
Lawyer Will says the judge was just annoyed Norm made him work harder.
That I did. That I did. Funny story, many years ago, I had a couple murder cases in Middletown, Connecticut. This has to be 25 years ago. And I was in Middletown for about 6 months trying these 2 cases. And I saw a good friend of mine one day, and he said, "How's it going in Middletown?" I said, "Man, these cases are killing me. They're just taking forever." And he looked at me with this twinkle in his eye that I didn't quite recognize. And he said, "What do you think those 2 cases have in common?" I said, "Man, I don't know." He looked at me, he says, You.
Yeah.
So anyhow, let's move on to ChatGPT and Jonathan Turley. We just got a chance to touch on this briefly the other day. Fascinating story. Turley is a prominent law professor here in Washington, D.C., and a columnist of some repute. He like the rest of us, is intrigued with ChatGPT. So he got a call from one of his colleagues, Eugene Volokh, another prominent law professor and blogger, expressing some curiosity and concern, perhaps, about Turley. He'd read, Volokh had, I guess, on ChatGPT, that Turley had once been accused of sexual harassment of a student while on a university-sponsored trip to Alaska. Now, most of us, when you get a call like that, it's like, "Oh, that's outrageous." You're angry. Turley was puzzled, and he was puzzled.
Look at the way this is. So this is an opinion piece from Jonathan Turley in USA Today. So this is directly from the horse's mouth. And he says, quote, "I received a curious email from a fellow law professor about research that he ran on ChatGPT about sexual harassment by professors." So there was a backdrop that Eugene Volokh was doing research on ChatGPT to see what ChatGPT would pull from public sources on the internet. The program promptly reported that I had been accused of sexual harassment in a 2018 Washington Post article after groping law students on a trip to Alaska. So that's some pretty specific and damning allegations that ChatGPT was making. But sorry, Norm, go ahead.
No, that's right. I mean, so it turns out Turley was much relieved because he'd never been to Alaska, much less groped a student on a trip there. And so this raises a question. There is his reputation being maligned by ChatGPT in a form that could support a claim for what's called defamation per se. Defamation or libel is harming someone's reputation by uttering something untruthful, and in some cases, the outrageousness of the untruth is so bad that you don't have to prove damages to get damages. That's what's called defamation per se. And accusing a person of a crime or some immoral or scandalous conduct is usually defamation per se. So, I mean, query, and
just to be clear, and he says here in the article, the Washington Post article that ChatGPT referenced did not exist. It was never written. There wasn't an archived version. It just did not, it never came to be. So this wasn't a matter of Eugene Volokh coming across ChatGPT saying this and then finding something and then drawing some comparison or contrast between an article that had been published and then what ChatGPT was saying. ChatGPT literally made the entire fact pattern up. There was never a Washington Post article to begin with.
Well, that to me is shocking, Mike. I mean, and it's more shocking than I realized because, I noticed an error in a ChatGPT story about me the other day, and don't be running that now. But it imputed a date to the beginning of my legal career that doesn't make sense. But I realized that it probably did so by faulty inference. I didn't go to law school immediately after graduating college. I went to graduate school. I taught in a university for a while, then kicked around in journalism and a couple other things. Wasted some time learning about the world, which I think has made me a better lawyer. But ChatGPT imputed an early law school graduation date to me, asserting as a fact that I had graduated from law school years earlier than I had. And I wondered, how did it do that? And so I thought, okay, it assembled data points. It probably was able to determine my age, the year I graduated from college. Somehow it couldn't find the year of graduation from law school, but it made an inferential leap that given my age and given certain other pieces of data, it was likely that I had graduated from law school in a certain year, but it didn't say that. It wasn't transparent in the inference. What it did is it made an assertion of fact that was untrue. It didn't trouble me. I just thought that's weird and untrustworthy, but this Turley thing is shocking to me, Mike, because it's one thing to draw an inference. Lawyer will, you'll know this. Those of you who are law nerds and interested in this and aren't lawyers, pay attention. You've heard people say, it's just circumstantial evidence. Circumstantial evidence doesn't count. Well, circumstantial evidence does count in a courtroom. Circumstantial evidence is the drawing of a reasonable inference from a fact otherwise established. And jurors are told daily, and we're fighting over the jury charge right now in the Biggs case. And I just read yesterday what the court's going to charge on circumstantial evidence. And it says, and the court will say, that circumstantial evidence is every bit as probative, every bit as reliable as direct evidence. We all rely on it all the time. And the classic example is you wake up, you go to bed one night, there's no snow on your lawn. You wake up in the morning and you look out, oh, it's a bright sunny day, but you look down, there's snow on the lawn. Did the neighbor put it there or did it snow last night? And those both are possible. It's possible that everybody in your neighborhood last night went into their freezers, froze some crystals, and got together to sprinkle them on your lawn to mess with you because they care that much about you and your reaction to the world. That's possible, but it's not reasonable and it's not likely. The likely inference is that it snowed last night, and that's the inference that most of us would reach all the time without thinking. So ChatGPT is presenting things as facts, which it infers, I presume, by some computational process. That's one source of misinformation that I can deal with. The Turley thing. How does ChatGPT make up an article in the Washington Post, Mike. I mean, do we have any idea how that happens?
No, and that's what he was saying as well, Norm. So he makes it a point to say that that he has come to realize that he is unpopular, right? Professor Turley says, quote, over the years, I have come to expect death threats against myself and my family, as well as a continuing effort to have me fired at George Washington University due to my conservative legal opinions. And I don't know why that went away.
Does he also have a thing for Candace Owens, according to
He
ChatGPT?
says,
Was that what that was?
as part of that reality in our age of rage, there's a continual stream of false claims about my history or statements. I long ago stopped responding since repeating the allegations is enough to taint a writer or academic, which is definitely true, especially in our day and age. But what he started thinking about is how insidious this was. At first, he thought it was comical, and then he thought it was insidious, especially considering those who are huge proponents of using ChatGPT and AI in general to get rid of biased and flawed media to combat disinformation. One of the names in particular referenced in this article is Bill Gates. So he's inherently suspicious of what is actually happening because there are big, big, big names involved with artificial intelligence, and yet this can happen, and there is no explanation.
Well, I mean, and so it raises questions about legal liability because, it seems to me that Turley could bring a claim against ChatGPT for defamation and for defamation per se, and the claim is stronger than ChatGPT simply making a mistaken inference. They asserted that a reliable source, aka the Washington Post, reported this. Now, I can tell you, given my reading habits, until I spotted the error about myself, I would have assumed that ChatGPT was reliable. So does that make me naive? I guess so. But now, if I'm reading this and I say, well, it was cited in the Washington Post, I would have no reason to believe that a carefully designed algorithm could miscite an otherwise reliable thing. So I might say, hey, I heard about this in the Washington Post, not living my life by a researcher's standards, in other words, having a citation for every source and every comment I made about facts in the course of the day. I might say, I heard the Washington Post reported that. And suddenly the comment requires a center of gravity that it otherwise wouldn't have. So who is liable for when AI causes harm? And in this case, would it be OpenAI, the creator of ChatGPT? And should Turley raise a claim? That we talked before about the Kissinger book, and that came out with he and several colleagues saying that ChatGPT is creating a fundamental alteration in human relations because, unlike the Enlightenment era, which made a practice of daring to know, of unmasking reality, trying to understand reality and how it worked in its units so that we could reconstruct it and build things for our betterment. We're now relying on an opaque device to give us information and to manage our lives. And we don't even understand how it generates the data that we rely on, but we rely on it. And so it's the classic black box syndrome. ChatGPT becomes a sort of information overlord to whom we turn for information. And it's now, we learn, feeding us information that may be wrong in trivial ways and may be wrong even in profound ways. And I would call this harm to Turley profound, given the fact that he's a public figure and all that other jazz that takes some of the sting out of it. But what if it was you, Mike, or what if it was me?
That's exactly right. And so Professor Turley talks about this. And what I did is I put the Future of Life Institute policy objectives on the screen because we talked about those last week. And I highlighted there, liability for AI created harm. And Turley says that there's a free speech concern over the use of these artificial intelligence systems, right? He actually testified before Congress about the Twitter files and the growing evidence that the government does have a comprehensive system of censorship to blacklist sites and citizens. And so he concludes his article by saying, quote, The use of AI and algorithms can give censorship a false patina of science and objectivity. Even if people can prove, as in my case, that a story is false, companies can, quote, blame it on the bot and promise only tweaks to the system. The technology creates a buffer between those who get to frame facts and those who get framed. The
Yeah.
programs can even, as in my case, spread the very disinformation they have been enlisted to combat.
Well, and that, I think that's a problem. I mean, we have tiptoed into it ourselves here on Law and Legitimacy. Mike informed us yesterday. I didn't know it till yesterday that we had 3 strikes against us on YouTube, twice for spreading quote unquote misinformation and once for encouraging violence. We don't know what we did to encourage violence. I will go to my grave knowing we didn't. But yet there it is, through an opaque censorship process. Again, misinformation, the claim is, I don't know what we did. Did we rely on some information from a third party that turned out to be untrue? We make an effort to try to understand our sources, to open a discussion. So somewhere, some algorithmic overlord has decided that we have transgressed an opaque boundary that we don't know about. And so we're going to contest it. We're going to fight it. But I don't know how hard we'll fight it, because time is short in life, and you have to make a calculated decision at the margins on each decision. Is this worth the effort or not? Is that worth the effort or not?
Well, and I think that there's also a transparency issue because we know for a fact that news articles for the last several years, in general, with these, especially these major media outlets, many of them are created by chatbot, right? Either they're dictated somehow, or there is ChatGPT will create an article and it will get published. So there's a transparency issue from a consumer perspective. If you're reading something or hearing something, whether the source of that information was artificial intelligence or whether it was a sentient human being, right?
Yep.
And we really don't know. So when these issues arise, it really only is in a retrospective glance, like Eugene Volokh was able to provide. And by the way, that one of those blacklisted sites that Turley references is the Volokh website, the Volokh conspiracy, I think is what it's called.
It is.
So, but a couple of things here. We have some comments here in the live chat, and hey to BTL and Lawyer Will in particular. BTL says ChatGPT made up information about my hometown when I asked it what it was famous for. I asked for sources and the links it provided were all broken. When you ask GPT, you can ask for sources and it will tell you what it thinks it's using. But my hometown was not a bad issue, but it used a landmark that obviously was not near it, which is really interesting, right? I mean, it's just sort of approximating these things. It's as if somebody said, hey, what can you find in, I don't know, Swain County, North Carolina, right? And then it starts giving you stuff over in Asheville or Black Mountain, right? Those are an hour plus away from each other, right? So that's not even remotely accurate, even though they're sort of, I guess, on a global scale, on a global map, maybe they're, you can argue that they're close. Will brings up an interesting point, and here we go. I may be introducing the notion of contracts of adhesion as we have sort of slowly dripped before. He says ChatGPT users have to agree to length terms and conditions that include a liability waiver. No? And
well,
I haven't used it, so I don't know. You have, Norm. So
I have, but I didn't read the contract.
Correct.
I mean,
well, I would assume that we could actually, and maybe we should, is go and get the ChatGPT terms of service, and as a follow-up to this, Norm, unpack what it would say about liability or prospective liability, indemnification, arbitration, all these things that they likely do.
So let's talk about it in the Turley context, though. So, to those of you who aren't lawyers, an adhesion contract is a contract that you must enter into to take a service, and it adheres to you. It sticks to the terms of those services. But it's a contract that you likely haven't read, and it's so overloaded with terms and conditions that benefit the drafter of the contract that there's a question about whether a reasonable person would sign on. But if you want to use the service, you must sign on. on. And so most of us who are online, you get to the thing, do you agree? And there's going to be 2,000 words of type that even Mike couldn't understand. Lawyer Will probably would. I wouldn't even try. I'd have to call those guys and say, what does all this stuff mean? But most of us just skip that, and we're so eager to use the service we accept. So then you use the service, you're harmed by it, and you want to hold the company accountable. And they said, oh no, you agreed as a term and condition of using our service that we would be unaccountable. And so the question becomes, if the contract is really about people making an offer of one thing for another and another person accepting it, and it's something of value, consideration being exchanged, and that if that's what a contract is and it reflects a meeting of the minds, can minds really meet when one mind closes its eyes and just signs saying, let me use it? Courts
two issues here. Yeah, two issues. One is that we know that every civil lawsuit has to have some form of damages, right? So if I think in the case of defamation and or libel, you still have to prove harm to your reputation, right? And that's an issue, because if this was research done by Volokh and Turley was unaware, I think by virtue of that USA Today article, he might be implicitly acknowledging that he hasn't suffered any palpable harm to his reputation, or because he didn't know about it. But that may not be the truth, right? He may have in fact suffered harm. He would just have to mine that out to find it.
But if it's defamation per se, he doesn't need to prove harm.
That's
and
very true.
Turley could have an action against ChatGPT because it's Volokh who is bound by the adhesion contract, not Turley.
Correct. And here's the other part. In general, liability waivers do not confer upon the person who is asking the user to waive liability for them. It doesn't confer to them immunity from their own negligence, right? So in this context, I would argue strenuously that the terms of service would not apply, but that's of course without having read them yet.
Yeah, no, I hear you. I think the really interesting issue here is, because it was research generated by Volokh, and Volokh told Turley, it seems to me Turley can't be bound or touched by an adhesion contract, and he could have a cause of action against ChatGPT. Whether it's worth doing or not, I don't know. But if it could, well, I mean, I think it. Actually, I do know. I do think it's worth doing. I think it's worth a test case.
Probably now more than ever, right? Yeah. And someone in Turley's position is probably one of the better people situated to take that on, especially on his own behalf. Thinking Man asked, would an adhesion contract be used when purchasing a self-driving car? I would say probably, right? Because they're big computers.
And then, of course, as Mike points out, you're injured by use of the car if it's because of the design. If there's a product liability issue or a negligence issue, you might be able to bring the action. But it's going to be a powerful barrier to seeking justice. And there may be choice of forum clauses in there that require you to bring your action far from home, or even to arbitrate the action and to avoid a jury trial. And that would address Mike's point. Even if they can't even if they can't require you to waive liability in an adhesion contract, they can require you to waive your right to a jury and bring an action in an arbitration forum. And there are arguments that violates the Seventh Amendment right to a jury trial, and litigation ensues. But I want to do a quick transition and tease to a topic that we're not going to have time to address today, but it seems related to me. Maybe it's not. There's a story that the Federal Reserve Bank is agreeing to use as central bank digital currency, I think of its own creation, to manage foreign accounts. And there's a lot of discussion about central bank digital currencies in domestic economy, replacing cash in a cashless society. We need to get back in touch with Jimmy Valley, Mike, in advance this, because I've suddenly become a digital currency skeptic. Yep. And I've become afraid of it because of the very thing we see in Turley and the Truth, the case of ChatGPT and Turley Truth. And that is, if we've got an opaque algorithm defining reality, telling us what we can get access to, telling us what's true and what's not, if we replace cash with a digital currency that is in control of a third-party algorithm, could our access to goods and services be turned off in the same way that Mike and I got a strike for inciting violence we didn't incite? Could some algorithm or the manager of some algorithm say, hey, you know what? we've heard enough from these guys. Let's let them chill off the market for a way. Or in the alternative, would social justice warriors say, based on your demographic characteristics, pricing will be based on demographic characteristics. In order to achieve reparations, a person of color is going to pay 75 cents for a gallon of milk. White men, having the privilege they do, will pay 5 1/4. And there's nothing you can do about it.
Well, and then, man, Norm, this can get very big very quickly. So maybe this Jimmy Valley discussion that we're courting here needs to be a long form, because I'll tell you this: the SVB and Signature Bank collapses and the ongoing issues with banks means that consolidation of regional banks and acquisitions is forthcoming, putting the power that banks hold in fewer and fewer hands. And to the extent the Federal Reserve buying through whatever digital technology, because I think I read the same article you did, it didn't strike me that the Federal Reserve was launching a CBDC or a central bank digital currency insofar it was authorizing and basically
fair enough.
Putting together a technology by which a CBDC could travel back and forth, right? So we're not quite there, but it does still make me quite nervous. We've seen the fractional reserve system basically become a joke over the last couple of months, and especially in retrospect. And then also the story that we won't get to again today in North Carolina, with the Republican legislature now earning a supermajority, a veto-proof supermajority. There is a bill that has been put forth to begin revising the power that the governor has to make appointments to various commissions and regulatory agencies, including putting the something I think to do with energy underneath the Department of the Treasury rather than the Department of Transportation, which is really interesting. And that's going to be a move that conservatives are making in an effort to, I think, forestall some of these same issues that we're talking about here. But that may be a bit tenuous, and I'll have to develop that connection a little more.
Yeah, no, but I think the centralization of power in the name of efficiency and the common good, it all sounds nice. We're going to govern for your own good, dear. But then it begs the question of who decides what's for your own good. Yep. I think I know Mike maintains, we maintain here that you make that decision, and that centralized institutions are a direct threat to individual liberty, even though they may be necessary to solve collective problems. So how these lines get drawn is a perpetual problem, and it's why there are laws and lawyers. Jacqueline P., good to see you here, young lady. She says these banks get bailed out by the government and are above the law. Wells Fargo's been bailed out, however, still foreclosed, double dipped on hundreds of thousands of houses. That's true. Hey, look, we need banks. I don't think we want to go back to barter. We need a government because cash makes the world go round, and it's how we transact. I think we need to place limits on how big these institutions can get and how much control they have. And we'd like to recenter and refocus our political discussion on these institutional concerns, because the identity politics that the country has engaged in has been a smokescreen. We've been so busy sniping at one another's characteristics that we're losing track of the characters that are becoming our digital overlords. So on that happy note, I'm going to object.
Overruled, counselor. Overruled.
I'm ready for court.
No, you are. I know you are. As always, I want to make a quick plug for us. You can find us on Twitter at Pat's Podcast. We're live on Twitter every morning. So if you would rather than trying to find us on Rumble if the notifications aren't working, or if you're on YouTube, you could have our notifications on Twitter, and we're live over there as well. Please consider subscribing to us on Locals. That's lawandlegitimacy.locals.com. And I just put up here on the screen the same thing about the Rumble subscriber badges. That's another way to directly support Law and Legitimacy going forward through the end of the year. Rumble is going to honor every contribution made 100% to the creators. So Rumble will not take any transaction fees or withhold any sort of percentage on that. So you can be assured that if you wanted to spend the $5 to become a monthly subscriber via Rumble, that every dollar, every cent would come to Norm and myself. Audio only listeners, you know that every day's stream is available directly after we're finished on Apple Podcasts, Spotify, Overcast, Google Play, and wherever you find podcasts. And I think my job now, Norm, is to see if I can't find Jimmy Valley and schedule a time for us to talk about this stuff. I'm really interested.
Yeah, we've got some talking to do to big man Jimmy. Yeah, let's get it done. All right.
Absolutely. All right. Well, Norm, we'll see you tomorrow. I will be coming to you live from Lakeside.
Oh, nice.
in Appalachia. So it'll be a different backdrop for me, but same bat time, same bat channel, as they say.
Works for me. Be well today.
See you later, Norm.